Good day, Crime Talk aficionados. Yes, Frank, the hardest working man in show business, is back in the house, which means he is in control. First on the docket, Judge Boyce permanently seals exhibits from the Chad Daybell trial. The Delphi defense attorneys want to make Judge Francis C. Gull a witness. A bike rider is lucky to be alive after being hit by an alleged drunk driver. And a Mcdonald staff member flips the scripts on a complainer and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can listen to us anytime on any of your favorite podcasting apps. All right, before we get to today's docket, that's right, Frank is back. That means we're going to have cool videos behind me and next to me. I was unable to do that, but I did put up that Justin Timberlake mugshot all by myself, and I did the intros as well. So there you go. Anyway, it's good to have him back. Hope you're rested, Frank. We got a lot of work to do. All right, so let's go ahead and open the record for June 20th, 2024. And first on the docket, Judge Boyce permanently seals some exhibits in the Chad Daybell matter. Now, I don't know if the judge thinks that this is like the Warren Commission that investigated the Kennedy assassination. Are we going to have to wait till all parties are dead to see everything in its entirety? Well, let's take a look at it. So it says that on May 30th, following the presentation of evidence by the state of Idaho and defense, a jury returned a verdict finding defendant Chad Guy Daybell guilty of all charges of the amended indictment. And then on June 1st, 2024, a jury returned a special verdict imposed the death penalty on defendant Daybell. On June 3rd, 2024, Daybell filed a notice of appeal to the district court, and the court has carefully considered the salient facts of this case, the high-profile nature of the trial, and the contents of the exhibits admitted and published therein. Today, the court considers the overarching policy considerations of Idaho Code, Section 19-5306, that victims of crime be treated with fairness, respect, dignity, and privacy throughout the criminal justice process. In cases involving homicide where the actual victim is unable to exercise those rights themselves, the courts in Idaho are to apply equal consideration to the immediate family members of the homicide victims or immediate families of victims of such youthful age or incapacity as precludes them from exercising their rights personally. Here, there are three victims of the homicide: Tylee Ryan, Joshua Jackson, J.J. Vallow, and Tamara Douglas. The court, in considering the future unsealing of certain portions of the record in this case upon final disposition, considers the following policy or allowing victims of their immediate families to be afforded the rights of fairness, respect, dignity, and privacy. Following the conclusion of the jury trial, this court received multiple requests from various individuals, including media members and authors intending to publish information about this case in their respective business ventures. Certain requests seek to obtain all of the exhibits in this case, with some expressly requesting the autopsy photos published to the jury in the case. The court notes that at trial, those photos were published to the jurors, the parties, the court, and in some instances, privately to the victims upon their request. They were not, however, publicly disseminated in consideration of the above stated policies. And the court here balances out the rights of the victims and the general public's right to case information, including those who have a vested interest in monetizing the tragedy surrounding this case. Now, the right of the public to information in a criminal case is clear. Footnotes, it says, from a recent Supreme Court opinion, this court has long respected the media's role in our constitutional republic and honored the promises in both the Idaho Constitution and the First Amendment of the United States Constitution. The underlying rationale of the First Amendment protection of freedom of the press is clear. The public must know the truth in order to make value judgments. The only reliable source of that truth is a press, which is free to publish the truth without government censorship. We cannot accept the premise that the public's right to know the truth is somehow enhanced by prohibiting the disclosure of the truth of the courts of the public. And that was a 1977 Supreme Court case there in the great state of Idaho. And then you always know there's going to be a however. Anyway, the right to information must be balanced against the policies stated herein, right? That's the however. Notably, the court was particularly moved by several victim impact statements at sentencing, expressly criticizing individuals proclaiming to be media. The court then has another footnote. The court is not here referring to established and historically recognized reporting agencies such as the Associated Press. Rather, the reference media pertains to true crime bloggers, YouTubers, CrimeCon participants, etc. So there you go. You have your right to obtain information is somehow reduced unless you work for the Associated Press, apparently, according to the judge in this particular case. But we read on. The right of the information must be balanced against the rights and policies herein. Note the court was particularly moved by several victim impact statements at sentencing, expressly criticizing individuals proclaiming to be media, who in the course of this case have disrupted the lives of the families of these victims in the past and now continue their efforts to sensationalize and capitalize on this case. Some of those family members describe in detail the psychological trauma they have been unfairly subjected to by the media simply because they have familiar relations to the victims in this case. It is the intention of the court to mandate the fair, respectful, dignified consideration of these victims and their immediate family members by finding the content of these exhibits is fairly classified as material, the publication of which would be highly objectionable to a reasonable person under the Idaho Court Administrative Rules. Accordingly, this court will, upon final disposition of this case, permanently seal the following exhibits. And it goes on, and there are some 97 exhibits that the court is going to seal. And it says the above referenced 97 exhibits, upon balance, are to remain sealed as the interests of the victims and the family members to be spared the ongoing trauma of such sensitive or gruesome material being disseminated is not outweighed by the right of a public disclosure of the evidence. Victims Tylee Ryan, J.J. Vallow, Tamara Douglas Daybell, and their family members' respect, dignity, and privacy are best protected by the continued sealing of the exhibits. The legal custodian of the above referenced exhibits are expressly prohibited from disseminating them without authorization from this court. Well, there you go. I get that there is respect and there is dignity to all the people involved. I truly appreciate that. And I would hope that the people that would want these exhibits would handle things appropriately. But think about it, ladies and gentlemen. We've seen murder scenes from all kinds of horrible cases throughout the years. You can see it on your local evening news or news magazine show when 2020 does their show, and they show you the pictures from the Helter Skelter murders back in the late 60s and early 70s, where they have Sharon Tate in her body and they have it blacked out. Things could be done respectfully. Okay, we obtained the autopsy report in the Chris Watts case. I think we handled it respectfully. We read it. We didn't get the photographs, but I take great exception, and I understand. I appreciate the family members. They don't want to see this stuff on the evening news. I get that. But we live in a free society, and as the court noted, the long respected the media's role in our constitutional republic and honored the promises in both the Idaho Constitution and the First Amendment. That's right. And the press is supposed to bring us information that may be disturbing, may be troubling, may make us think about what took place. Who knows? Some of those photos could greatly affect how people perceive the legal system, as maybe it's too soft, maybe it's too hard. But the public has the right to know. I just have a real problem with the court saying, basically, you, unwashed, you are too stupid to be able to handle this. And let's face it, if this information was released, hopefully people would handle it respectfully. But if you don't have to, or you don't want to look at it, you wouldn't have to. No one's forcing you to do that. But you can go on the internet and you can watch terrible things being done where people's heads are being chopped off of reporters and things of that nature. You can see the horrible atrocities that took place in Israel. You can go find it if you want it, but you don't have to watch it. But the people that see it are forever affected, and it changes their minds on some certain policy issues. So I have a real problem with the court saying, you can't do it. We can't trust you with it. I have a real problem. Like I said, this is not the Warren Commission. This is not the Warren Commission. This was a public trial where these items have been thrown out there, presented to the jury. Heck, those images were apparently disturbing enough to make the jury say that this is what was worthy of the death penalty. So why would it not be worthy for the rest of the public to know as well? Let me know what you think below. Is Judge Boyce, did he do it correct? I got a real problem with things being done in secrecy. You know, the reporter from the Wall Street Journal, he's going to get his trial in Russia. Oh, but it's going to all be behind closed doors. Oh, isn't that convenient? All in the name of security, right? Because it involves national security. This is not a national security case, ladies and gentlemen. I'll leave it at that. Let me know what you think. If I'm wrong, I get it. Let me know. I can deal with it. I just think in a free and public society, every free and open society, you have to be able to have information out there that may be troubling. It may be disturbing. And that's good. People need to see troubling things. They need to hear troubling things. They need to see troubling things because that's reality. And by not saying it doesn't exist out there, doesn't put us in some little bubble, doesn't protect us naivete, I just got a real problem. All right, next on the docket. The Delphi defense attorneys want to make Judge Francis C. Gull a witness. That's right, the defense attorneys for the Delphi murder suspect, Mr. Richard Allen, has filed their latest salvo in a contentious legal back and forth involving the defense, the prosecutor, and yes, the judge herself that has been assigned to this case. Anyway, Richard Allen, for those who don't know, is charged with 4 counts of murder in connection with the February 2017 deaths of Abby Williams and Libby German near the Monon High Bridge in Delphi, Indiana. Well, the Indiana State Police announced his arrest in October of 2022, more than 5 years after the killings, and he's currently awaiting trial. Now, the Indiana Supreme Court assigned Special Judge Francis C. Gull to the case after the original judge recused himself. Now, Allen's attorneys have tried multiple times to have Judge Gull removed from the proceedings, accusing her of bias. So far, that has failed. The state's highest court has even declined to take Judge Gull off the case as of yet, and the judge herself has denied 2 defense motions seeking her recusal. In the latest motion filed by the defense, they claim that the Carroll County Sheriff's Office lied about the circumstances surrounding the transportation of a Westville Correctional Facility inmate for a June 2023 hearing, and that Judge Gull contradicted the Sheriff's Office report about the matter. Now, there may be different interpretations, but you got to be very careful when you start saying people are lying, okay? There could be a mistake that was made, a misunderstanding perhaps. You better be absolutely certain before you say somebody lied. Anyway, at a hearing that was scheduled for June 15th about Allen's safekeeping, i.e. at the prison system versus at the county jail, his attorneys wanted an inmate to testify about the harsh, abusive, and unconstitutional treatment that Mr. Allen is receiving at the Westville Correctional Facility. Now, the inmate was a guy by the name of Robert Baston. Robert Baston was the key witness in the hearing, according to the defense. However, Baston refused to come out of his cell to testify on that particular day, so he couldn't be transported. Sheriff's Office report indicates that Sheriff Toby Leesenby, after being contacted by the jail staff, called Gull's office to inform them about the situation. The report from the Sheriff's Office indicated that Judge Gull's office had advised to leave Baston there if he did not want to attend the court hearing, according to the defense motion. Well, then in May 31st of 2024, there was an order. Judge Gull wrote that the decision by the deputy to leave without the witness was his and was not directed by the court. So Allen's attorneys say that the May order was the first time they noticed a discrepancy between the sheriff's account and what the court is saying took place. So that information from the May order was part of Gull's response to the latest attempt by the defense to have her removed from the case. Now, Allen's attorneys allege that Judge Gull didn't make the defense aware of the discrepancy before her May order and never admonished the sheriff's office for filing a report that apparently contained such a flagrant falsehood, and which is arguably an attempt to cover up their illegal actions in ignoring a valid defense subpoena. Anyway, the defense contends that Gull's statement effectively make her a witness for the defense, and Judge Gull should recuse herself from the matter as she is now a witness in the proceeding, the defense wrote in their motion. Now, the motion also contains responses to Judge Gull's allegations that the defense team improperly filed some court documents that it intended to shield from the prosecution. Gull said the documents had been filed as confidential, which kept them out of the public view instead of ex parte, which would have kept them away from the prosecution. Now, the defense argues that the documents were filed correctly and blamed the court staff for incorrectly providing the information to the prosecutor. In this case, and after the defense correctly filed the ex parte motion, somehow the court staff erred in how it processed the documents in their system, causing the prosecutors to have access to the ex parte document, according to the motion. Now, the defense said the motion was intended for the purpose of preserving the issues for the record. Now, the attorneys argued repeatedly that their desire to have Allen, who's currently housed at the Indiana Department of Corrections facility, moved to the Cass County Jail or the Tippecanoe County Jail while he awaits his trial, which is now scheduled to begin in October. We'll see. That is going to be one nasty trial, ladies and gentlemen. The judge, the prosecutor, the defense attorney, none of them get along. Well, the prosecutor and the judge, not the defense with anybody else. And it is going to be knocked down, drag out, and we will see how nasty it will be. Hopefully, it will be recorded. But once again, the judge, we just can't have these high-profile cases. The people, we just can't. No, we can't let the people know what goes on in these courtrooms because they can't handle it. They're not smart enough to know what's going on. That's really what they're saying, ladies and gentlemen. When they're saying we can't have cameras in the courtroom, they're saying you're too stupid to understand what takes place. So don't bother. Don't bother. All right, we talked about Justin Timberlake the other day on his arrest there in New York. But guess what? Thank goodness he did not hit someone or harm someone, because this next story shows a cyclist that's lucky to be alive after being literally run over by an alleged drunk driver. So a retired physician is lucky to be alive and credits his bike for saving his life after he and another cyclist were mowed down in a brazen hit and run near a Texas airport on Monday. Now, Benjamin Highlander, a cargo team member at American Airlines, is accused of running over cyclist Tom Geppert, who's 69, and Deborah Eads, who's 65, who were part of a group of bikers riding around the Dallas-Fort Worth International Airport at 6 p.m. Now, Highlander was seen rapidly approaching the riders in a white Subaru Forester, initially striking Eads before clipping Gepster's back tire, which launched him into the left lane until he fell on the road. Now, all of a sudden, he said, something pushed me forward from behind, Gepper said as he was explaining it to the police as well as the press. Then I could feel myself falling from the right, and then that's pretty much the last thing I remember. Now, Geppert said he lost consciousness for a few minutes in the horrifying crash, and doctors performed a CT scan on Geppert's brain and diagnosed him with a concussion. Now, he said that he feels like he's 100%, but that he has some fractures to a rib on the backside, which makes things a little tender. Anyway, Highlander is captured on footage allegedly driving over the biker. Geppert was rushed to the Baylor Scott and White Medical Center in Grapevine, 5 minutes west of the crash, while he was treated for severe lacerations. Now, Geppert, who has since been released from the hospital, said he's just overall amazed how lucky he is in the fact that he is still alive. Eads was treated at the scene for several lacerations. Several cyclists chased after Highlander to a Shell gas station, telling him to return to the scene of the crime. Now, Highlander attempted to speak to one of the injured cyclists, shouting, "I'm sorry," but pulled away by officers once they arrived on the scene. Now, what did investigators find? 6 empty cans of Voodoo Ranger Juice Force IPA in a backpack in Highlander's car, and 2 cans of Coors Light in the grass near the parked SUV. Guess what? Mr. Highlander failed a field sobriety test and a breathalyzer test as well. That's right. While talking to the officers, Highlanders allegedly mentioned he was maybe drinking a beer an hour before the crash in Grapevine, but the number of drinks changed throughout the interview. That's right. It's always a couple. Anyway, Highlander was charged with 2 counts of intoxication, assault with a vehicle causing serious bodily injury, accident involving injury, driving while intoxicated, driving alcohol concentration greater than 0.15, according to his arrest records. And he is being held at the jail on a $36,000 bond. And American Airlines is saying, hey, he wasn't on duty, and he's basically suspended as of right now. All right, next on the docket, a little bit of a flip of the script for all of our food workers that get assaulted, I guess you could say. So we have a McDonald's employee this time that shot at a customer who is complaining. That's right. Take a look at this. A Florida McDonald's employee was arrested last week after she was on a store video camera chasing down customers and firing. That's right, firing a gun at their vehicle after they complained that their order was wrong. In a Facebook post by the Lakeland Police Department titled McMahon, said they were called to a shooting about 1 a.m. on Friday. Investigators said the incident began when the customers complained about their order and the employee, a Chastity Gardner, argued with them about it and then threw a drink at them as they were leaving. Now, 2 of the customers then got out of the vehicle and opened the drive-through window to throw drinks at Gardner, who then armed herself with a handgun. The customers decided this would be a good time to drive away, but Gardner walked outside with her gun and fired at the vehicle as it pulled out of the parking lot. The vehicle was struck at least once. Anyway, take a look at the video from the surveillance camera showing the entire incident as Gardner walks outside and returns to the store with the gun in her hand. Ms. Gardner has been charged with aggravated assault with a deadly weapon. Now, the McDonald's employee handbook does not mention weapons inside the restaurant, so apparently it must be okay. And earlier reports say the company abides by state and local laws. In Florida, gun owners do not need a permit to purchase a firearm, a registration for a firearm, a license to own a firearm, or a permit to carry a rifle. Handgun requires a permit to carry. Seems like a reasonable state law to me. Anyway, seems like could be a dumb criminal of the day, but she kind of flipped the script. Maybe it's a little overkill, right? Tough day. Take a deep breath. Take a deep breath. Don't need to shoot at the customers. They are the customers. The customers are mostly right, sometimes right, maybe, I don't know. But I don't think it warrants shooting at them unless they shoot at you first. And anyway, our dumb criminal of the day, it's a throwback. We talked about Justin Timberlake being arrested the other night in the Hamptons, which we went down the memory lane, doodaloop, 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 doodaloop. That's right. It was also in the Hamptons that Billy Joel slammed his Mercedes-Benz into a tree in Sag Harbor. That's right. And Joel also told the police at that time that he had a glass of champagne before drifting off the roadway and encountered the tree head on. Prior to that crash back in 2003, Billy Joel had been drinking at the American Hotel, where Justin Timberlake was drinking a few adult beverages before his driving while influenced bust took place. And then, yes, who can forget Martha Stewart? Back in 1997, she had a run-in with some gardeners who were working on a property next to her mansion there in East Hampton area, where Stewart apparently had been feuding with the next-door neighbor, a developer, and when she arrived home that evening, she found a landscaping crew working on the property. Believing that the landscapers had installed a fence that encroached on her land, Miss Stewart drove her SUV into the other property owner's driveway and confronted the workers. And after being told by the workers that they had not constructed a fence, Miss Stewart became extremely upset and got quite angry at the man and called him an effing liar. After being told yet again that they were not responsible for the fence, Miss Stewart apparently started yelling, "All you Whitmore guys," referring to the property, "are effing liars. You're no good. You're no good." Anyway, while still yelling, apparently, allegedly, Miss Stewart backed out of the driveway, and then the employee claimed he was pinned between her car and the security entrance keypad that stuck out from a concrete pad on the ground. And he had to say, "Hey, you're crushing me. Help, help, help." And then ultimately, apparently, Stewart, looking right at him, kept backing up. Now, as the car was crushing the worker into the security device, the mirror collapsed forward, and the guy was able to get away and get into the bushes. And the Suffolk County District Attorney subsequently declined to file criminal charges against Miss Stewart, who they said initiated the confrontation in the mistaken belief that the landscaper had erected a property line fence incorrectly. Now, although the possibility of injury was present, prosecutors noted such injury thankfully was averted and the worker was not seriously hurt. The district attorney at that time concluded the confrontation, as objectionable as it may appear, does not warrant arrest and criminal prosecution. This decision did not sit well with the East Hampton police officers, though, who believed there was probable cause to charge Miss Stewart with reckless endangerment and attempted assault. Apparently, they were soft on crime in the Hamptons back in 1997. So, Miss Stewart, you are now, I guess technically, our dumb criminal of the day, because, hey, and I really like Martha Stewart. I mean, other than she didn't say lawyer, lawyer, lawyer when she was questioned on that insider trading, didn't go to prison for insider trading. No, she went to prison for lying to the FBI. Lawyer, lawyer, lawyer. Anyway, Justin, if you need me, call me. Martha, if you need me, call me. All right? Snoop Dogg, you need me, call me. We'll help you out. That's all we have for you today, ladies and gentlemen. Thanks for joining us. We'll see you next time. And remember, the Constitution matters.